So I think we're going to get started. I want to welcome everyone back for day 2 of EPA and the future of environmental protection. We've got a couple of great panels, unfortunately running in parallel, but we will understand if you are here for some of the first one and next door for some of it. In here, we will be discussing the evolving relationship between EPA and the DOJ Environment and Natural Resources Division with 4 wonderful experts. I will just introduce your moderator, who is Andrew Mergen, the Deputy Chief of the Appellate Section of DOJ. And the panelists are going to be thinking about the evolving relationship, thinking about what works, and thinking about looking toward the future, as has been the theme for the conference. How could the relationship be structured differently to be most effective? So thanks again for being here. We look forward to more discussion today, and enjoy.
Can I just use this one? Does that make sense? Yeah, so my name is Andy Mergen. I'm a Deputy Chief of the Appellate Section of the Environment and Natural Resources Division. It's a pleasure to be here with 3 of my former colleagues, 2 of my former bosses. And then I look out in the audience and I see a lot of my other bosses, both present and former. There are full bios for the speakers online, but I will just briefly kind of introduce you to this excellent panel. Lois Schiffer was both Assistant Attorney General of ENRD at the Justice Department during the Clinton administration and General Counsel of NOAA during the Obama administration. She has just a tremendous wealth and breadth of knowledge of an environmental law, and has, in my experience, has always been super passionate about it. Ron Tenpass was the Assistant Attorney General during the end of the Bush administration. He's also been a U.S. attorney. His credentials are phenomenal. Editor-in-chief at the Virginia Law Review, Rhodes Scholar, clerk for the late Chief Justice William Rehnquist, and also, I would just say about both of them, phenomenal bosses, just incredibly great people to work for, from whom I learned a tremendous amount. I also have learned a lot working with Stacy Mitchell in her past life as chief of the environmental crime section at DOJ. She left that job to join EPA as deputy general counsel in the Obama administration. There's more about them online, but I can assure you that this is a tremendously qualified panel of really not just excellent lawyers, but excellent people and great people to work for and with. What we're going to do initially is to do some table setting and just to introduce you to some of the historical aspects of the DOJ-EPA relationship, and then sort of an introduction to the organization of both EPA and DOJ. So Lois is going to do some table setting on the history of this evolving relationship between EPA and Justice. Stacy will talk about EPA organization as it relates to the DOJ relationship, and Ron will do the same for DOJ. Broadly speaking, right, DOJ interacts with EPA in a couple of ways. In the civil enforcement context, in the criminal enforcement context, in the defense of agency action, including rulemaking, other agency decisions, failure of the agency to act, and then also, very importantly, in those circumstances where another federal agency might be liable under a CERCLA as a PRP, there's a possibility for tension in these relationships, and there's also the possibility for just incredible teamwork. I always think as a former rower that when you get together with a team and you have sort of 8 people in a boat, you're looking for that feeling of what rowers call swing, that moment when everything is working together. There's absolutely no friction, and all of the power of each individual is being applied to a goal, and it feels like that's what we're always looking for when DOJ partners with its client agencies. And with that in mind, maybe the part of the goal of this panel is to talk about getting that swing. I'll turn it over to Lois.
Well, thank you. I'm glad to be here. I have 10 minutes to cover 50 years of history, so it's going to be from the highlights. I want to make two opening points. The first is I'm the granddaughter of immigrants, a point I feel important to make at this time. And I'm nevertheless here. And also that I taught for 30 years at Georgetown Law School environmental law, so I'm very glad to see that we have what looks like some students in the audience, and you shouldn't be intimidated by the old timers like the rest of us, but be amused by our stories. So the EPA was set up by reorganization order in 1970, and for those of you who were here yesterday, you heard some of the back and forth about whether Nixon was the greatest environmental president or not. At that time, the Justice Department had been operating since 1870, so it had had about a 100-year history. And the Justice Department operated under statutes that said essentially it was the lawyer in court for the United States. EPA was given huge amounts of responsibility and very ambitious goals. For instance, the 1972 Clean Water Act said that the waters needed to be cleaned up in 5 years. And it had a lot of young, enthusiastic, smart people. It was then called the Land and Natural Resources Division at the Justice Department, which sort of described its focus, and it was given authority under this large number of new environmental statutes, aggressive environmental statutes. The average age of the person in the division was probably 80. The average experience was some public land cases or land acquisition, and it was all white men. There were a few women, and they were sort of relegated to the backwaters. Section chiefs would say, I won't work with that person. So it was not, these models looked quite different to start out with. I will tell this by way of a story. So the person who was head of the lands division in the Carter administration was a man named Jim Mormon. And Jim, who had been head of, or until he was at the division, was head of a Sierra Club, part of the Sierra Club in San Francisco, and had been in the lands division doing water cases about 10 years earlier, said that he was picked as the person. He got back to San Francisco to sort of get ready to come, and he had a frantic call from the Associate Attorney General saying, you better get back here right away, you're about to lose half of your jurisdiction. And what happened is that EPA, who this is my own guess, was sort of tired of the incompetent lawyers, the lawyering that they were getting defending their new aggressive regulations, was basically going to say, we're not going to use those people anymore. They had some authority for that because in most of the environmental statutes, and I pulled the Clean Water Act one, there was a provision basically saying that EPA could give their cases to justice, but if justice didn't act quickly, they could handle it themselves. So there was some backup. But nobody wanted to give up authority either. So basically, the Attorney General and the administrator of EPA negotiated what I would call a truce, but they call a memorandum of understanding, which is you can still find in the Federal Register of June 1977 through the miracles of Google. And it actually looks remarkably like the Justice Department manual today, which sets forth how the Justice Department is going to operate to handle both civil enforcement cases and environmental defensive regulation cases. But it had a few tidbits I thought that I would pick out and tell you. It says, agency, meaning EPA attorneys, shall not file any pleadings or other documents in a court proceeding without the prior approval of the Attorney General, and the Attorney General can delegate. So it was clear EPA was off on their own, too. On the other hand, it says the settlement of any case in which the Department of Justice represents the agency or the administrator shall require consultation with and concurrence of both the administrator and the Attorney General. So Justice was probably settling cases without getting EPA's approval. And it goes on. It was clearly a quite eroded relationship. So by the time I got to Justice in 1978, I was not handling EPA cases particularly, but I was aware of what was going on. And there were challenges because the person who was in charge of enforcement at EPA wasn't the most vigorous person, and so there was a certain amount of tearing out of hair. And but time went on, particularly when the Superfund program came into being in the statute was passed in the late 1980s and late 1980, and then it had to be up and running both by Justice and EPA. EPA was under the challenge of Rita Lavelle, and so it wasn't so clearly established right away. Justice was vigorous to do it, and there had to be more cooperative working relationships as a result. By the time I got back in 1993, we were back to erosion again, because environmental crimes had been a big challenge, and there had been efforts by, and Stacy will probably talk more to this, but there had been some efforts to consolidate authority in Washington. There had been cases that criminal referrals that EPA wanted brought that the Justice Department was not bringing. There were U.S. attorneys who felt they were being cut out of the picture, and it was in general not a good relationship between EPA and Justice. I came in eventually as head of the Environment Division, and the head of enforcement at EPA was someone named Steve Herman, who had worked for me at Justice. I had hired him, and we were friends. And we basically said, we're getting over the turf fights. It's not going to happen anymore. And we will make that clear in our own behavior. And so we will tell people that if they are having trouble, they should elevate it, and then you and I will get it resolved. And that message helped enormously. But it was also backed by various written arrangements. For example, EPA could bring cases administratively, and in some of the statutes there was a penalty cap on what they could get, and otherwise the case had to be referred for civil enforcement. The idea was the more serious cases would come to the Justice Department for civil enforcement. And there had been a view, I don't know if it was a fact, but a view that EPA was bringing cases with low penalties so they could hold on to them. And we eventually negotiated arrangements so that there would be a more serious and joint approach to cases. So and that held. On the criminal side, where I said that there were very eroded relationships, we developed a new, what's called a blue sheet, which is a piece of the U.S. Attorney's Manual that sets forth what the arrangements are going to be. And that helped to calm the waters both with the U.S. attorneys and then to some extent with EPA. And in general, we made clear that there needed to be better working relationships. If you have good working relationships, as Andy said, you can have terrific results. And so we had, for example, a series of very big civil enforcement cases. For instance, we sued a group of power plants. Those cases, some settled, some went on for a while, but that was really getting at huge amounts of pollution. We said that the power plants hadn't complied with certain provisions of the Clean Air Act that required pre-approval before you constructed a power plant. And similarly, we had what now seems ironic, but which is we had relatively early cases where auto manufacturers were tinkering with the computer systems in the cars so that they would act one way when they were taking the tests that EPA was giving to just set the model, and quite a different way on the road, i.e. a more polluting way on the road. Those cases were called the defeat devices, is the term of art in the statute. And we brought a whole group of defeat device cases. We couldn't have done that if we didn't have really good working relationships with EPA, who could work on the technical parts of that and then work cooperatively with both the Maine Justice Department and U.S. attorneys' offices and states who had a stake in that too. So the cooperative working relationships could really lead to significant cases. And I will make my last little pitch and then turn the panel over. So, and I will say that as I was at NOAA in the Obama administration, and we worked with the Justice Department both on our cases and to some extent on EPA cases where there were NOAA issues, we could see that in general, relationships with EPA were certainly significantly improved. So my big points are that you have to look both at the formal arrangements, which are written down and continue to be written down in manuals. You have to look at the informal arrangements. How are people working it out in addition to the formal arrangements? So, for instance, that a serious case will be handled in a civil court case rather than a civil administrative case. and that a less significant case may be handled administratively without turf fights being the deciding factor between justice and EPA. And then you have to look at the personalities. And like everything else, there are lots of personalities around this, but leadership can really make a difference in conveying to people that turf isn't the way to do it and cooperative working relationships are. So.
Good morning, and I'll echo is structured, feels daunting, but nonetheless, I'm going to launch in. As Andy indicated, I spent 3 years during the Obama administration, or nearly 3 years, at the EPA in the Office of General Counsel. It was actually that time that really elucidated some of my comments that I will be speaking to for the rest of the panel, because it made me understand how EPA ticks and how it really does function. And that is not a perception that I had as clearly while I was at the Justice Department. And so sort of further to what Lois was just saying, a lot of actually working on relationships, human relationships, I think are really the key to the future of a functioning relationship between the two agencies or the two entities. So my job is to talk about the EPA organization. EPA has a headquarters organization here in Washington, D.C., and then regional offices, 10 regional offices around the country. They are particularly recently structured largely the same, with programmatic offices in each of, both at headquarters in each of the regions. The programmatic offices predominantly being air, water, land, which really think RCRA, CERCLA, and then pesticides. And I shouldn't just say pesticides, chemicals and pesticides. So those are the groups. Then in addition to those sort of programmatic areas, there are, and probably the places where there are the greatest amount of relationships between the Justice Department and EPA are through both the Office of General Counsel and the Office of Enforcement and Compliance Assurance. And understanding that matrix and who does what and how they interact with one another is probably the key to the relationship between DOJ and EPA. The Office of General Counsel is, as the name suggests, it is the agency's general counsel. Largely, it advises the administrator and the programmatic heads on their policy work, to include, of course, regulatory development, drafting regs, and works with the programs to help, take the technical people, put the law with it, and pull it together in regulations. And then in Office of General Counsel predominantly works with the Justice Department in the defense of those regulations, whereas the Office of Enforcement and Compliance Assurance, OECA, that is, as the name suggests, where most of the enforcement emanates from the agency that will go to the Department of Justice. OECA is, again, broken down programmatically, and then for civil enforcement, and then there is the Office of Criminal Enforcement, and within that there are a cadre of fewer than 200, although statutory obliged to be 200, criminal agents that are scattered not only at headquarters but throughout the regions. As far as how referrals come through, it happens differently from civil and criminal. And I think we'll get into this in a lot more detail, so I'm really going to do very high level. But in the civil level, there is an inspection or some other lead that comes into EPA. An EPA inspector does an inspection. There's then the building up of the case within EPA, and then subsequently a referral over to DOJ. Those referrals largely start DOJ's involvement. There are some exceptions to that, but really it is the referral that starts and triggers the relationship. On the civil side, on the criminal side, it's actually quite different. What happens typically is an investigator gets a tip, and from that tip, they may need assistance from either the Department of Justice or an assistant U.S. attorney to develop through the grand jury the case. And so there'll be an earlier collaboration between building up the case. As far as the regions go, the relationship between the regions and headquarter are always, well, there are 10 regions, which means there are 10 different ways to do it. The regions largely do on a regional level what happens at headquarters, except for there's not regulation writing. But the regions are involved in and give information to the headquarters with respect to regulation writing. And that probably is enough of a setting. And I'll move it over to Ron to talk about DOJ.
So my stage setting role here is a little bit to talk about some of the internal aspects of DOJ, as talked about with respect to EPA. Start with one observation. You can sometimes tell where people gain their footing within DOJ. You can sometimes figure out a little bit where people got their initial footing within DOJ by how they speak about the department. Actually, so I am somebody who was born and bred in the U.S. Attorney's offices in the field. I was an assistant United States attorney, then became a United States attorney. That morphed into a headquarters assignment in the Deputy Attorney General's office, doing a lot of policy-related work, congressional oversight, those kinds of things. And then was named Assistant Attorney General as my final post within DOJ. So one of the giveaways a little bit is how people speak of the U.S. Attorney's offices. And at least one of my bugaboos on this is some people will speak of DOJ and the U.S. Attorney's offices as if they are separate entities. In fact, although no U.S. attorney will readily admit this, they are part of the Department of Justice. It's similar to frankly, how the FBI speaks of itself at times. You work for the Bureau and you speak of the Department of Justice, despite the fact that your seal is, one of the 15 or 20 that is in the office of the Attorney General representing all the places that he's the boss of and oversees. So all that to say, there is some work to develop swing, as Andy put it, even within the department amongst these couple of places that all have some role in environmental litigation. Now, certainly at the heart of that is the Environment Division. 400 lawyers, has litigating purview over roughly 150 statutes, environmental statutes, some vaguely environmental in that there's a group, for example, that does the major condemnation work of the United States, kind of hearkening back to the division's foundation as a group that was litigating largely over lands issues. You think about, as Lois pointed out, the division had its birth, John, help me, 115 years ago now, 110? When was the 100th anniversary? Thereabouts. Well, there were not meaningful environmental statutes at that point. What there was the giant West being settled and largely owned by the federal government, with a whole variety of lands issues arising from that. So kind of from that beginning, the Environment Division, for example, picked up condemnation work as one of its areas. But by and large, you have 400 attorneys. They are about evenly split between what you would call top-side work and bottom-side work. That's a litigator's reference to, if you look at the caption of the case, it's always somebody versus somebody. top side is United States versus somebody. Bottom side is somebody versus United States. So is the government suing or is the government getting sued? That top side work, the government suing, breaks out into sort of two components, basically civil and criminal. And certainly within the civil, that is overwhelmingly handled by the Environment Division. And within that, a group called the Environmental Enforcement Section, roughly 140 lawyers who kind of specialize in what we would generally call the pollution statutes, Clean Air Act, Clean Water Act, some of the chemical regulation and pesticides, FIFRA, those kinds of things, and also the CERCLA cost recovery enforcement actions. Then you have a group of about 40 attorneys in the environmental crime section who work on largely around that same group of statutes, but adding on top of that things like the Endangered Species Act and the statutes that are not EPA agency statutes to investigate tend to fall to Fish and Wildlife and similar kinds of the wildlife agencies. I'm going to put them aside a little bit and circle back to that group because to understand that work of that group, you got to talk about U.S. Attorney's offices. It's a little bit of an overstatement, but for the civil enforcement matters, by and large, you don't need to think a lot about the U.S. Attorney's offices. They occasionally get involved. They will, when cases are brought in a particular district, they will often have an attorney assigned, but really to provide very much local expertise about that judge, that court, those proceedings, the procedures in that jurisdiction. So let's flip quickly to bottom side. That has sort of two major components. One is the regulatory rulemaking defense, at least with respect to EPA, I should say. The regulatory rulemaking defense, so when the agency is sued for the new regulation not being strict enough, for it being too strict, for it not being promulgated at all, that body of cases is largely handled by a group called the Environmental Defense Section, to some degree with the involvement of the appellate section as well. And then you have a group of cases where the United States, having been the polluter, so to speak, is itself potentially responsible for helping to pay for the cleanup of these large Superfund and other similar sites. So you can imagine that private companies that are most frequently on the hook for that are more than happy to invite Uncle Sam to the party when they think that, for example, the Department of Defense or Department of Energy program or something along the way has contributed to that pollution problem. We may get into this. I will just say that situation leads to a pretty interesting challenge when you are the AAG, because ultimately you can have a case in the Superfund arena where the government is basically suing on behalf of EPA, the environmental enforcement sections, suing to make sure a place is cleaned up, perhaps to have EPA have its costs repaid. It has sued a bunch of private companies. Typically, those private companies have then found a government agency that they think is also responsible. So they have brought those agencies into the suit. So you have the environmental defense section defending them. And so ultimately, if there are disputes there about the resolution, the place where that reporting meets for the first time is in the person of the Assistant Attorney General. The supervisory structures are generally otherwise kind of separated a little bit. And so you are put in an interesting position at times in terms of adjudicating the positions of two parties that you simultaneously, in some sense, represent. And let me turn very quickly to a couple of other headquarters units that are important to at least recognize. One is the Office of the Solicitor General. On on major cases where you can tell there's a big policy kind of issue, a piece of the statute that is being litigated that has been long contentious as to its meaning. Even at the district court level, you may undertake some work to consult with the SG's office to make sure they're going to be comfortable with positions that the government is adopting in the lower court. Ultimately, if the case is adjudicated and there's going to be appellate work, particularly if the United States wants to take the appeal because it lost, you need the approval of the Solicitor General's office to do that. So depending on the nature and prominence of the case, you may be talking with them very early. You're certainly going to be talking with them as if the United States has gotten an adverse decision about what to do. And then, of course, there is some very select body of cases that go to the Supreme Court. And in those, the somewhat like DOJ having kind of exclusive litigating authority for most of the agencies, the SG is the lawyer of the United States in the Supreme Court. And so that at that moment, a case typically is handed off to the SG's office, although with a very close working relationship. Folks like Andy are beloved by people in the SG's office because they basically, bluntly, they know how to write a Supreme Court brief, and they often do, at least in the opening stages or petitions for cert or petitions to oppose cert. So you have that group. It's worth always mentioning your boss. As Assistant Attorney General, my boss was the Associate Attorney General, the number 3 individual in the department. So there are certain things that you're reporting on to them, you know, your biggest cases. You basically, you never want them to read in the morning news about something that you haven't told them about, and, you know, preferably multiple times over the preceding 3 or 4 months. And then let me flip back finally to basically the U.S. attorneys. So there are 93 U.S. attorneys' offices across the country. Each one of them is, you know, unless the job is sort of temporarily vacant, is appointed by some, filled or led by somebody appointed by the president, confirmed by the Senate. In Washington and within the department, things like that matter. Maybe they shouldn't, but people, once they've been confirmed by the Senate, are convinced that they got there by merit only, and by the insightful wisdom of the president personally, in seeing that you were the only person for the job. And
You feel that way?
you know, both times, you know. And U.S. attorneys are certainly of that, broadly of that species. And in particular, a U.S. attorney's office is, their staffing is, in most offices, probably 80-20 in terms of attorneys, 80% criminal, 20% civil. That affects the operation of those offices. Bluntly, for the most part, most U.S. attorneys think criminal is where the action is. That's, you, as U.S. attorney, you never get a headline for your office having successfully defended the Federal Tort Claim Act brought against the Postal Service for the driver who ran into, you know, your neighbor driving home. You know, bluntly, you get your bones, you get your publicity, you get your psychic satisfaction for most of them out of the criminal cases. And so they attend to what's going on in the districts on criminal cases quite closely. They care a lot about it. And so that leads to variation across the country in terms of how involved the U.S. attorneys are in the particular environmental criminal cases in their districts. Some have established AUSAs who are full-time environmental dedicated prosecutors. Others, if you have an office of 8 or 10 AUSAs, I mean, some offices are that small, you can't do that. In that kind of situation, you probably embrace and welcome the environmental crime section, environment division attorneys, because they've got expertise, they've got capacity, they're willing to travel and come to your district, they're willing to work with your AUSA. So the Environmental Crimes Program has this kind of element that is both of headquarters and of the Environment Division, but also of the United States Attorney's Office, and with some variation across those U.S. Attorney's offices. I think that's probably a place for me to stop, Andy, and we'll go from there.
So one thing I should have mentioned in my intro is that what's great about our panelists is that they're all litigators. They all have appeared in court on multiple times and are very comfortable answering questions. In fact, my experience as a litigator is I hate to appear before a cold bench. I'd rather engage with a court, and I know that's true of our panelists as well. So this is what we're going to do for the rest of our program. We're going to start talking about civil enforcement, about that relationship between DOJ and EPA. Also, focused on looking forward, what makes for a good relationship, how we can get that swing, that flow between the agencies to maximize the expertise and skills that are resident in the components. We'll start with civil, we'll go to criminal, and then we'll talk about the defensive. But the thing about these litigators is you should feel free. I will keep an eye on the audience, and you can ask questions all along. So we'll start with civil enforcement, which is as Ron mentioned, the civil enforcement component of ENRD, of DOJ, is the largest in terms of the number of attorneys. And that tells you, I think, something about how important that work is to the EPA-DOJ relationship. And so we'll segue into civil enforcement. I just want to start by sort of asking the panel, talk about the referral process. Ron used a really good couple of words, capacity and expertise, and that may be one way to look at the referral process. What should EPA be thinking about in a civil referral? What expertise does DOJ bring to the table in terms of looking at those referrals and building the case? And going forward, what does a good referral and case look like on the civil side?
Well, I guess I'll start. The first point I would make is sort of a step before your premise, and that is, in an ideal situation when things are working well, it's not a piece of paper that gets lobbed from EPA to Justice, and Justice says you're missing 5 things and lobs it back. A much better, I mean, I've always said no ping pong. A much better way, a much better way to do it is for EPA gets the information from the investigator or the inspector, or gets a tip and certainly is knowledgeable about it. But if and we should separate out small cases from big cases, but for a significant case, it works much better if both agencies are working together to sort of say, this is what we're going to do. This is a big case. We probably should start involving both the regions and the U.S. Attorney's offices. Sometimes for pollution cases, it's useful to involve the state, which may be either the Attorney General or the pollution agency in the state. That's a sort of another component of this. But to really say this is going to be a hard, complicated case, what are the kinds of information we need? What are the kinds of experts we need? How is somebody going to figure out the computer system that causes the defeat device? Because the average lawyer sitting at their desk isn't going to know the answer to that question. So a good referral is thorough, but it doesn't necessarily mean it was all developed at EPA without the benefit of any consultation, and then comes over. For the much smaller cases, and there are certainly a number of those, EPA brings to bear the inspectors who go out and check the information that they get from states or other sources, sometimes from citizens, and can take that into account and develop it with the scientific knowledge that they have and write that up in a paper that comes to the Justice Department. The theory is Justice can then use that to develop a complaint and go to court. But in practice, there's likely to be more back and forth. And the more that back and forth can happen in a cooperative, let's get together and meet about it way, the more likely we are to get to a good result of protecting the environment.
I think, there's fairly little to add to that. I mean, that is, Look, a perfect referral is, in some sense, one in which, at the point EPA itself feels that it has substantial and sufficient evidence for a civil complaint to be filed, or a defendant to be contacted pre-suit about whether it would like to entertain settlement options. The perfect referral is one where, at the moment EPA reaches that conclusion, the DOJ lawyers looking at it say, we absolutely agree. There is not a flaw in the package, and we think this is sound in every respect with no, and we're happy to draft the complaint, so to speak. Realistically, you're rarely going to get that kind of perfect referral, if for no other reason than, you've got a lot of smart people involved and good lawyers, and a second set of eyes looking at something will often spot a difficulty that maybe the agency hasn't been as attuned to. I guess the other thing I would kind of add to that is, I think that's a bit the role of the Department of Justice. Personally, I always liked working with, or from a supervisory standpoint, I was always kind of interested to know on the quiet, the line attorney who's proposing this and says we're good to go. Tell me if they've ever gotten their teeth kicked in before, in a trial. Have they ever lost a case? Have they tried? How many cases have they tried? Because there is, I think, one aspect that DOJ brings to the table here, when it's at its best, is a certain amount of sobering influence. There is something about having been the attorney in the courtroom that the judge is yelled at. There is something about being the attorney who, in a prior case, when you ask the key question saying, did you observe this to happen? And where they told you 10 times yes, they blurt out no, and you have this kind of moment of panic. Those kind of experiences, I think, are helpful to bring as a bit of a reality check, and that's a healthy thing. But I would say, I think folks from the agency, not as often having had to sit in that position, can sometimes be optimistic and enthusiastic. You want that, you need that as part of the folks who are really working to develop cases, but you do need some folks who will provide some check on that, and with a realistic view of all the ways in which, once you get into court, the unexpected happens.
So one of the things that I hear you saying is that DOJ, as the folks who are going to be appearing before the court, they want to make sure, right, that they're not going to get their teeth kicked in, and so that seems,
Or at least
like,
I didn't.
they didn't. That's part of the skepticism, the questions, all of that is part of it. Is also, I mean, one of the things I think about I think both you and Lois have touched on, is that the role of DOJ in both having a role in the defensive litigation on the environmental side and the enforcement side. Does that sort of inquiry and focus on the potential problems begin at the referral stage?
For cases where
We're
defending
civil
EPA?
enforcement?
I'm sorry.
As for civil enforcement, where are we looking at? Where does DOJ play the biggest role in sort of resolving tensions between the government's role as defendant and topside, as Ron said?
Well, leave apart for a minute the Superfund cases, which where as Ron has correctly said, you're kind of on both sides of the case, and they're especially complicated. But for instance, at NOAA we had implemented the Endangered Species Act, and Interior also implements the Endangered Species Act, and there's basically a truce about which species are on which side of the line, which is beyond the scope of this discussion. And But we and NOAA and Interior had different points of view about how you interpreted the Endangered Species Act, and that would be an example where the Justice Department would need to get involved in, if this goes to court, if we say the species, we list it one way, taking into account factors, and it goes to court, are you going to defend us, or are you going to say that Interior has the right interpretation of that? So that's an example of where, not at the Assistant Attorney General level in the first instance, but with the section that has the expertise in that the Justice Department section that has the expertise in the statute, the agencies can get good advice, and the flip side is justice can give that advice by saying, we have experience with this statute and this is what we think, or this is why we think these arguments are better than the other arguments. And I thought it was one of the privileges of working at the Justice Department that you really got to kind of adjudicate those matters, hopefully by listening to people first and doing some reading about it, but then deciding that this is the sensible interpretation of the statute, or this is a defensible interpretation of the statute. I'm not sure that answers your question.
Andy, one other place I'd add is there are places where, so I think what Lois helpfully raised was places where, as to an environmental statute, there may be multiple agencies within the government that think they have some stake in how that statute is understood, enforced, interpreted, and Lois gave you a great example. Another place where these kinds of things arise, I think, is at more what you might call meta-principle levels, where there is some issue of law that affects not solely the environmental statutes, but a whole range of statutes that are important to administrative law. For example, I don't think it is any particular secret that there is some ferment about the Chevron doctrine and sublevels of that, something called hour deference and Skidmore. I'll stop there because Andy knows 5 times what I know about that arena. But that all has to do with the degree to which the executive branch gets some amount of deference from the courts in interpreting, implementing, and enforcing various statutes, particularly in the civil context. That's a question that's obviously very important for environmental law, but it's hugely important in financial regulation. It's hugely important in healthcare. And so one of the other roles I think that DOJ has and the Environment Division has here is to be sensitive to kind of these bigger meta issues that may be playing out, may be particularly important within a certain administration, that they have staked this out as an area where they are looking to make change, amend, influence the direction that law goes. And sometimes I think DOJ is the place where you find the lawyers who are most sensitive to those broader legal currents that one has to be sensitive to, that a particular environmental case may require, present an application of. And I'll give you just one other quick example of that. Tribal issues. This has tended to come up, I think, a little more in the criminal arena, maybe than civil, but there are a whole variety of treaties that all seem to talk about hunting and fishing in the accustomed places, and all seem to have been signed, sometime between 1820 and 1890, as far as my indoctrination went. And so you get circumstances, for example, where for a U.S. Attorney's Office may be quite interested in prosecuting some kind of hunting or fishing activity that occurred within their district, viewing it as, for example, violative of the Endangered Species Act, but where the defendant is a member of a local tribal community who may claim that pursuant to that treaty, they are protected. That is a very, very complicated area of law. Every one of those cases presents kind of important and precedential questions. It's actually an area that's getting some amount of attention recently, and it looks like that Justice Gorsuch, for example, has some interest in this area rooted in his days in Colorado. So again, an area where the Environment Division, because it has two sections that deal with tribal issues, sometimes, being sued by tribes, sometimes vindicating tribal rights, brings that kind of special expertise.
And Andy, I just wanted to jump in quickly and disabuse everyone of the notion that it takes multiple agencies to have a disagreement about the interpretation of a single statute. We in OGC on a regular basis would sit down with folks in a particular programmatic office, somebody in OECA, and maybe even in multiple different offices, and attempt to mediate the disagreement on how to interpret a statute. In a perfect world, going back to your question, Andy, we've done that. We, the agency, had done that before referring the case. What I found in real world was in the Office of General Counsel, we would have a weekly meeting with the various and sundry attorneys in that law office to hear what they were working on. And in our position, we would have both the sort of the broader policy perspective of the agency, as well as understand the implementation of the various statutes. And inevitably, from time to time, somebody would be discussing an enforcement action, and like a cat, my hair on the back of my neck would stand up, and I'd say, well, that's inconsistent with the way we need to interpret it to win this case. And so really, it is complex. And I know, Andy, I had a number of disagreements with you when I was in the criminal enforcement section, sort of not understanding and appreciating that tension that sometimes exists. So certainly you hope that the agency works it out, but we do, and I attempted when I was at General Counsel's office to work closely with DOJ to have those discussions, which were sometimes tense, but at least because we knew each other, there was trust, even though they were tense. And I really do, you're going to hear me say this a bunch of times, I think about getting to know the people at the other agency. And if I'm looking forward, I like the notion that people who have been at EPA go to Justice, or people who've been at Justice go over to EPA. I think that helps in the long run of how these agencies work together.
Do you have a question?
them what my catechism, that DOJ won't help us because DOJ has always told us that
Well, you have to sort out several pieces. So it is, in general and in this circumstance, correct that Justice Department doesn't sue one federal agency on behalf of another federal agency. And there are limited exceptions to that, but for these purposes, that's the general rule. So that there have to be other ways to get it worked out. And so if your caller is suggesting that somehow EPA isn't requiring DOD and DOE to pay enough for the Superfund cleanup, which is what I'm inferring from what you're saying, the remedy for that is not going to be that Justice sues DOD and DOE. That isn't to say that Justice can't weigh in, and somebody can come to Justice and say, this is the Superfund circumstance. If Company X out there, who was also a polluter at the site, were to challenge it or bring something in, what would be how would you think about this? The Justice Department may be available for informal approaches. That said, it is certainly correct that there's more vigorous enforcement and less vigorous enforcement in different administrations. And I will say even in the Clinton administration, where I think we had a very strong and effective enforcement program, there were some cases where we would go to EPA and say, why aren't you doing anything about lead paint? And kids are getting poisoned. That's not so good. Well, first of all, the statutes aren't so excellent. That was a problem. But secondly, we basically got HUD to say they would do it because EPA wasn't so vigorous about it. And then EPA said, oh, us too. So the Justice Department can have a role in it, but it is correct that the role isn't going to be suing one federal agency on behalf of another one.
EPA headquarters when we
We've
had.
got a mic.
Thank you. In the late 1980s, the agency installed some carpet at headquarters, which caused people to get sick. When the word got out that EPA was poisoning its own employees, my union office phone started ringing off the hook, and I was hearing from people around the country with the same kind of problem. We filed, ultimately, we worked out arrangements for the employees, but we also filed a TSCA Section 21 petition with the agency to take some actions. On the day of the response, there are two elements of this what I'm saying. The agency said we're going to, the guy from OGC came down and said we're going to deny this petition. What was published in the Federal Register was that we didn't prove with scientific certainty that the chemical that we asserted was responsible for this was in fact responsible for it. We filed suit pro se, myself and the chief steward in federal district court here in D.C. We got run over by EPA's attorneys. And we cited a decision that came from, I don't know if it was OGC or one of the attorneys in the Office of Toxic Substances that had written an opinion that EPA took the position that it did not have to prove beyond a scientific certainty an enforcement action that they were taking against the Chemical Manufacturers Association. And we said, you apply a different standard to us suing you than you used against CMA. What gives here? Was DOJ advice involved in all in that kind of petition denial? Because what the basic reason for the denial then was actually the OGC person came down and said, we're going to deny this petition bill because it would cost the carpet industry billions of dollars if we did, granted. We'd have to find that the carpet posed an unreasonable risk, and he didn't say that. He just said it would cost the carpet industry billions of dollars. And later on, and he said, we're going to do instead, we're going to convene a carpet policy dialogue, and we're going to try to work out what the problems were and X, Y, and Z. Later on, I figured what we were asking for didn't involve billions of dollars of effort by the carpet industry. But what it did involve is all those people who called me and wrote letters to the union office are lined up around the block in court filing lawsuits against the carpet industry because EPA said this carpet caused what posed an unreasonable risk, and they granted a petition under Section 6 of, the petition was under Section 21, but they granted Section 6 remedies, which required a finding of unreasonable risk. And that's what it was all about. And that was really problematical. I won't identify the person, but he said, "I'll deny having said that if this ever comes out."
I'll just stop you there because I think you've identified something really important about the DOJ institutional role, because you mentioned that what you had done, which seems laudable and smart, is petition the agency for action. And one thing that's interesting about DOJ's role, right, is that, and one of the things that we bring to these questions is sort of what is our overall institutional interest. And our overall institutional interest is in making the barriers for petitioning agency action to be not insignificant, right? Because that is our institutional role on the defensive side, is to give the agencies the space to do their work sort of unencumbered by litigation. And I think that's sort of that is what you've hit upon in terms of the relationship between your petition and the ultimate action and the denial and any judicial review of that denial, is the sort of institutional role of DOJ in looking broadly about how people get to court and what the standards should be. I want to take a second and switch to criminal enforcement, and because that referral process is very. Did you have a question?
You have two questions.
Oh, sorry. Yes.
Question. I have a question.
Yeah. Okay. Sam.
So this is a question for Stacy. As the person who's worked both at Justice and at EPA, I'm curious as to what you saw as the differences in the decision-making processes about legal cases in one agency versus the other. My perception when I was at Justice is that at Justice, when there was a potentially couple of different ways you could handle a statute or an issue, two things surfaced. First, the attention focused on whoever the poor soul was who had to go to court to explain this. That person quickly became, in many ways, a broker of what you were going to say, because that person was saying, well, that makes sense and this doesn't make sense. And the second thing is everybody focused on what would pass muster with the court. What will the court buy? And then you'd take these same questions and you'd go to EPA, and this is a somewhat facetious sense of how the decision-making process was what's the biggest way we can frame this issue possible that will involve the most historic grievances inside of the agency and disputes there, and who are the people who have been working on this issue the longest? And those are the people who should take center stage in any discussions about this. So what often seemed to happen is you would send a relatively, not junior, but a sort of person who was trying to figure out, how am I going to not get my teeth kicked in court, to go talk to people who would say, you don't understand, we've been working on this for 50 years. And so after being in both agencies, what can you tell me that would help me understand that?
So let me add a layer to that, although I don't think it will be that big of a difference. My roles at the two agencies were dramatically different. I was a prosecutor at the Justice Department. My sole role was to win my case, or to win the case. And I do think that this perspective is a part of an answer to your question. At the EPA, I was Deputy General Counsel. I was advising the administrator and the various sundry media offices on forward-looking policy. Where do they want to go? What are the goals and the policy objectives? And I think if you take a step back and you look at the goals of each of the agencies, and Lois, I'd be interested in your layer on this from a NOAA perspective as well. DOJ has less of a policy role, and as such, they're focused on litigation, and they're keenly focused on litigation. I will tell you, it was a year and a half into my tenure at EPA, still fuming over a particular series of cases that I was not permitted to bring at DOJ. And I finally understood the bigger policy problem with the cases I wanted to bring. I understood that the agency didn't disagree that those cases should be brought, that there were clear violations of law that were causing them to pull their hair out. But if you enforced there, what was it going to do, on a whole host of other policy issues? How was the agency going to defend some of its own actions? How was the agency going to move a greater policy forward? It was a much bigger question. Having said that, if you were going to refer a case to justice, you have to be prepared to litigate the issue. And so I don't know that I'm answering your question. It's certainly in the Office of General Counsel. We didn't go look for the oldest person to give us the history, but those who don't know history often repeat it. And if you don't know what the pitfalls are with respect to a particular statute or the position you're taking, you may in fact step into a new problem, maybe not in that case, but in future problems.
So I don't think this is necessarily a question about the roles of justice and EPA, frankly. To me, if you're being a capable lawyer, you look more broadly than just the little facts that are in front of you. And that's particularly true if you're a lawyer for the government, where you have some obligation. But frankly, if you're a lawyer for anybody, where you're better off kind of looking at how this fits into the whole big picture. And a real example of that, Ron was giving the excellent example of what I'll call procedural questions that come up. Half the Supreme Court Administrative Procedure Act cases are environmental law cases. I mean, it's not at half as a guess, but it's certainly many. And so, but to be litigating those cases in an effective way, you really need to think about a little more broadly than just my little case that's in front of me. That said, sometimes it's important to sort of charge ahead anyway, and a piece of that is to go back to EPA and say, I understand you think this affects your 20 other areas of the law, but we got to move ahead here. And I get it that you've had many meetings and you've discussed this for many years, but we got to have a decision. And there is nothing like litigation to give you deadlines, and there's nothing like deadlines to get a decision. And some of it is that. I mean, that you can get so paralyzed by thinking this affects every agency of the government that you don't move forward. So there's some balance between understanding that likely in the government this is more than just the one case that's in front of me, and being in a position to move ahead.
Current and future.
It's lovely to see you, Ellen. The states, I don't think anybody up here or that have done it have ever disregarded the states. The states were a primary focus, both even when I was doing criminal enforcement. I mean, we often looked for task forces that involve state and locals. On a civil side, Lois has already spoken to, on big cases, you immediately contact the Attorney General or the state agency. And I can speak from my time in the Office of General Counsel that working with the states through ECOs or individually when an issue came up was tantamount. I mean, it was a huge focus. And it was a recognition that the federal enforcement, particularly, is very small. I mean, I talked about the, maximum 200 agents. I don't think on a criminal enforcement perspective it's been at that number for years. It's 140 agents nationwide. I mean, you absolutely need your state and local partners. And I think that's a great way to move forward. I think that happens even more effectively from the agency. From the regional offices. I mean, really, those regional administrators are on a regular basis interacting with their state partners, and the like. So I think that from the EPA perspective, it's ongoing and sort of routine. And even from a DOJ perspective, on individual cases, that's always you always want a state involved. They may add complications, but nonetheless, that's where it matters.
I'd say, I think there's some real complexity in that relationship. I sort of take from your question, for example, a certain view of the current administration. Well, some state AGs are plenty happy with this administration. Admittedly, some aren't. And you could about do the mirror image of who was happy and who was not with the prior administration. I mean, there were a whole collection of states who sued over the proposed waters of the United States definition and regulation of the prior administration. Some have now changed where they sit on that because of the most recent elections. But there will be presumably a new proposal and likely a new regulation finalized by this administration. And you're going to have the kind of the flip side of the litigation that started in 2016. All of those involve state AGs. So right. Well, I think so. As to those, I think Stacy is right that you, at least from an AAG standpoint, I think the Environment Division does participate in a variety of the state AG groups. There's a Western AG group. There's various regional ones. I had, as one of the people who work with me, John, you can update me on whether this is still the arrangement, but we had one person on the staff who was probably 50% of their time was devoted to working liaison work with the various AGs to make sure you always had that relationship. There were people you could call within those offices where you thought you had a case that would be benefited by the state AG involvement, or where, as a courtesy, you knew they were likely to have sufficient interest in it that they'd want to be a part of it, even if they didn't have tremendous resources to bring to it.
I would also add for the most effective U.S. attorneys' offices that were big enough to have this, they had task forces that were basically federal, state, and local people who discussed both criminal and civil cases. And I don't know, but I would expect that in a number of places those task forces are still ongoing. Many of them have operated for a while, and so that there is the sort of policy litigation, and then there's the everyday litigation. And for some of the everyday litigation, that's really on a track that would be likely to keep going.
I wonder if there's time. Is there one more question that Amanda?
Indulgence, because I have a lot of my students in the audience, to turn this for the last 3 minutes into a career panel and ask if you all had a couple of words of advice for rising environmental lawyers. And although we're mostly forward-looking, I would ask that you give them some advice in what they may view as not an environmentally friendly administration. Is this a time? Well, what are your thoughts about next steps after law school if you're looking at an administration that you're not sure matches your views?
So let me jump in first because I'm going to be a contrarian on some of this. We can have a long discussion about this issue. My personal view is, for example, that the Justice Department and the Environmental Enforcement section that brings the civil cases, and the criminal section, and the U.S. Attorney's offices are not well served by having, for example, in the Environmental Enforcement section, 140 lawyers who primarily all got their first stop in their first job in the Environmental Enforcement section and then have spent their careers there. I do not I do a fair amount of international work. Some of my colleagues that I work with in the United Kingdom are amazed and dismayed that we seem to have this pattern in Washington and in the United States in particular, that lawyers go back and forth between government, private practice. They go back and forth between the NGOs and government. I think that's incredibly healthy for the department as an institution. Now, it may not be necessarily the most desirable and satisfying path for any individual if you have your mind to do one thing. But my overall advice would be, I think, first of all, be open to diversions, be open to doing a little bit the thing you don't think you ever really wanted to do. That's leavening and that's important, and it provides both perspective and training.
Well, I'm fine with going in and out of the government, but I also believe in a career civil service, which is not inconsistent with going in and out of the government. And particularly at an entry level, which is what is going to happen with your law students, you're likely to get experience, and you're going to learn to do research. You're going to learn to have discussions with people. You're going to learn how the government works. And so I would say that federal government jobs are very good jobs if you can get them. I mean, part of what we're suffering from now, I think, is that fewer people are being hired. But the chances that an entry-level lawyer is going to make a decision about what the waters of the United States rule should be are not really great. Fair enough, right? And so, but people will learn to do research about what are different sides of an issue, what is the actual legal background, and maybe handle some cases and get to go to court. So I would say that there's still terrific jobs, and I would be interested in doing them.
Yeah, and let me add to that. I mean, notwithstanding the controversy that always will surround any administration, there's always somebody on the other side who's got a critique. They're doing too much, they're doing too little. There is a broad, in my view, there is a broad body of cases, civil and criminal, that are the day-to-day grist of what EPA civil investigators handle, what the DOJ attorneys handle. There are regulatory cases defending agency action that are sort of not controversial, I guess I would say, across administrations, across leadership. Everybody would say, that's a case that needs to be done. This is an agency action that needs to be defended. It might not have been the choice I would have made, but there are sort of principles of agency discretion that are fundamental here. And so I think, to echo Lois, the other thing I would say is ignore some of the Sturm und Drang about, is this a good moment, a bad moment? Because there's a lot of good work to be done in any time, in any administration, in either of these two agencies, whether it's EPA or DOJ.
I would also add that state agencies, either pollution agencies or attorney general's offices are very good first jobs too.
And so I'm being careful not to interrupt my two former bosses over here.
Come on, put in a plug now for the state prosecutor's offices. That's where you got started.
That's actually what I'm going to do. So I studied environmental law at Tulane many decades ago. And my dream job was to go into the Department of Justice as an honors attorney. And I tell the story and I joke that I've never even got a no. Like, they just took my resume, cut it in half, used the backside as scrap paper. And yet, fast forward 20 years, I was chief of the environmental crime section. I ultimately applied laterally, and I will tell you that denial, if you can call it that failure to respond to me, was one of the best things I think happened to me in my career. I started out for the first 4 years of my career doing street crime. And really what I did is I got yelled at by judges for 4 years, and I became a much more confident litigator. I never dreamed that I would be doing my first trial was an unlicensed general vendor selling umbrellas. And yet that helped me become a more confident and better litigator. And I told, when I was at the Justice Department and I was on our hiring committee, I would say routinely at the beginning of an interview, so that nobody thought I was sending any message, I don't know you, I don't know how this interview is going to go, but let me tell you two things. There are so few jobs in the environmental world, but you can get to the job you want a bazillion different ways, and take your career path, take what it throws to you, get the best out of it, and then reapply it to what you want to do down the road.
As the only current government lawyer, I would just echo the point I think all the panelists have made, that there is tremendously good work to be done in the government right now, and it is an unbeatable place for people to get experience. For people studying environmental law now, I say to you, this is the best time I can think of to study environmental law, because there is this tension between promise and precarity. Right, we can look out and read the newspaper and say, well, maybe environmental law is in a precarious position, but maybe that's the moment where there's the most promise. And I think it's an incredibly exciting time to be studying environmental law. And I would say to you, one, get as much experience, different experience in the law as possible, because we all know that the best lawyers in the Justice Department are people who have the widest range of experience, that have done a lot of different things, because that experience all helps you down the line. And then the other thing is always just keep an open mind. There's always sort of a groupthink going on about things. In the classes I've been teaching, we've been looking at Trump and Obama regulations. And what we find when you drill down is sometimes one administration does it better than the other, and it's not always the administration you think it is. You have to pay attention and you have to keep an open mind, and that's going to make everybody a better lawyer down the line. We're out of time.
Thank